Hello, folks. Time to prepare for the ring. The actual fight is about to begin. So, we are going to cover today in our SQE 1 window session preparation for the trial. So, that's very, very important. So, imagine the court sends you a trial date like a mysterious royal invitation, not on a card. Your first job is to make sure your client witnesses and advocate actually, lawyers or barristers, they actually show up. Yes, that means confirming attendance and gathering instructions. Your barristers are need a proper brief. You need to brief them about the case, not a cheeky note saying good luck and a skeleton argument to wave at the opposing side. Remember, preparing is very, very important. And also, paying fee upfront can prevent awkward conversations later. So treat it like topping up your Oyster card before rush hour. Otherwise, you can put not only your client in trouble, yourself in trouble as well. So, next we summon the troops. The witness is like all of them. Under CPR 34, they must appear or face contempt of court, fines or worse. Normally, there was someone who was asking, is it necessary for me to go to court? I have work and all. I told them, if you don't, it is contempt of court. Offer them travel expenses. No one likes paying to attend, court out of their own pocket, although it is very necessary, but you need to cover everything. So, and don't forget your funder or insurer. If they don't know about the trial, they might be more surprised than a jury when evidence lands. So, court says pay up or else the trial fee via N173 you need to pay to the court as well. It's not that cheap. Ignore it and the claim gets struck out faster than you can say CPR. That's it, it's all gone. Need expert to zoom in, want to play CCTV footage, make arrangement early and get arrangement from the other side. Think of it like organizing a wedding. Everyone must know the timing, otherwise chaos. And not only chaos for your client, chaos for you, for your license as well. The trial bundle, the most important. It's a maze. It's kind of long document. It's your legal Swiss Army knife, it gets everything. Claimant usually assembles it, unless the court says otherwise. Review reports, update evidence, and get agreement on the index. Nothing screams professional like a well organized bundle ready 3 to 7 days before trial. Think of it as packing for holiday. Everything in its right place, and you shall be digging otherwise in sand. So be careful so you get everything in. So what is in trial bundle? The content is vast. Skeleton argument, witness statement, expert report, CPR 18 request, and more. Load of them. On this slide you can see them. Format matters too. So you need to have cross-referenced in a neat binder. You need 6 copies at a minimum. If your bundle look like a pile of soggy fish and chip, the judge will notice, and not in good way. Yeah, so be organized. That's one of the tip for you. So day of trial, on the day, arrive early, meet your team and breathe. Take a deep breath. Address the judge correctly, my lord, my lady, not, hey mate. Stand when they enter, bow politely. It's courtroom yoga. So it's courtroom kind of yoga. You need to perform bowing down. You're not bowing down to person, you're bowing down to the chair. Mobile phones, silence. Shocking, keep it minimal, dress formally. No one wants to see you questionable tie or flip flop. So be mindful of all of these etiquettes. So Trial proceeding and questioning witness. The day follows opening submission, preliminary issues, witnesses, experts, and closing submission. Witnesses first confirm their statement. Simple stuff. Cross-examination is where the fun begins. Closed questions slightly antagonistic, maybe a leading question if the witness is hostile. Remember, leading questions are like Marmite. Only allowed in specific circumstances. Otherwise, you can't ask leading question. Otherwise, judge will interrupt you and will say, shut up. They usually don't say shut up. So that's from me only. Sometimes jury judgment and cost. We need to understand that sometimes you have a jury, fraud, malicious prosecution, false imprisonment. In that case, you will have jury selection, challenges, minimum numbers, all rather like choosing a cricket team, but with higher stakes. Judgment can be immediate or reserved. Costs follow soon after. Money orders must be satisfied within 14 days. Advocates or, barristers are immune from suit unless the mistake is really, really silly. Think tripping over your own wig level of incompetence. So another thing that we need to understand is finally tips and pitfall. Always check trial bundle deadlines, witness obligation, and trial fee payment. Address judges and counsels properly. No cheeky shortcuts. So if his name is, for example, her name is Jennifer, no Jen or Jenny. So at that point, know when you can use leading questions and understand post-trial cost procedures. And the common pitfalls are missing deadlines, misaddressing judges, address them in other way, ignoring witness summons. Basically, don't be the person everyone talks about in the corridors of justice. Keep your cool, follow the CPR, and you will survive trial day, hopefully with your sanity intact. Sometimes there are questions from this area as well, how to address a judge. So be mindful of the fact that how you can prepare for it. Thank you very much for your time, and hopefully this makes sense. This session makes sense. To learn it further, once again, go back, download our notes, and those will help you. Ta-ta!